My name is Jeannie Schindler, and I'm a research fellow here at the Center for Cultural and Pastoral Research. As you may know, the center was founded to bring the rich theological and philosophical work of the JP2 Institute to bear upon pressing cultural problems, especially those affecting the most vulnerable: children, the elderly, the sick, and dying, and to promote conversation and common reflection upon these matters with individuals from a variety of disciplines, in order, in the first place, to best comprehend the issues in question, and, where appropriate, to develop a pastoral response to them. Our aim is to illuminate the anthropological and theological depth of these issues, dimensions that are often neglected in public discourse. To this end, we have initiated a lecture series featuring speakers whose work in some way dovetails with the center's mission. The work of tonight's speaker is centrally pertinent to the center's concerns, as this work addresses the most fundamental questions of human dignity, the sanctity of life, the nature of science, medicine, and law. Professor Carter Snead, our guest, is an internationally recognized expert in public bioethics, that is, the governance of science, medicine, and biotechnology in the name of ethical goods. His research explores issues relating to neuroethics, enhancement, stem cell research, abortion, and end-of-life decision-making. He has authored over 40 journal articles, book chapters, and essays. His scholarly works have appeared in such publications as the NYU Law Review, the Harvard Law Review Forum, and the Yale Journal of Health Policy, Law, and Ethics. Professor Snead teaches at the law school at the University of Notre Dame. Go Irish. Woohoo! Beat Michigan. Oh, we did that. We did. Oh. Handily. Carter is also the director of the Notre Dame Center for Ethics and Culture. In addition to his scholarship and teaching, Professor Snead has provided advice on the legal and public policy dimensions of bioethical questions to officials in all three branches of the US government and in several intergovernmental fora. Prior to joining the law faculty at Notre Dame, Professor Snead served as the general counsel to the President's Council on Bioethics, then chaired by Dr. Leon Kass. Professor Snead led the US government delegation to UNESCO and served as its chief negotiator for the Universal Declaration on Bioethics and Human Rights. In 2008, he was appointed by the Director General of UNESCO to a 4-year term on the International Bioethics Committee, the IBC, a 36-member body of independent experts that advises member states on bioethics, law, and public policy. The IBC is the only bioethics commission in the world with a global mandate. Tonight, we are privileged to have a conversation with Professor Snead about the problem of persons, public bioethics, and contending moral anthropologies. Please welcome Professor Carter Snead.
Thank you very much, Jeannie, and thanks to all of you for coming out this evening. It's a real pleasure and honor to be with you tonight. Catholic University is a wonderful place, and the John Paul II Institute is an inspiring place, and this center that is hosting me this evening is also inspiring to me. The center that I run at the University of Notre Dame, our mission is to share the richness of the Catholic moral and intellectual tradition with all of the students, faculty, staff, leadership of the university, and also to project Notre Dame's voice into the public square in the name of authentic human dignity and the common good. So we have a lot of goals in common, my center and your center. So thank you for having me this evening. Tonight, I'm going to be talking about public bioethics. Jeannie offered a brief definition. I'll recapitulate that definition momentarily for you. And I'm going to make an argument to you this evening that the best way to understand the disputes in public bioethics here in the United States and on the world stage as well, the disputes over things like abortion, stem cell research, human cloning, end-of-life decision-making, and the like, is not through the lens of conservative versus liberal, or religious versus secular, or traditional versus progressive, or any of those sort of shop-worn dichotomies that we're used to applying to this domain. I think the richest way to understand, to explore, and to critique arguments and positions in the context of public bioethics on these vexed questions and other questions is through the lens of what I'll call moral anthropology. And Jeannie alluded to this in her remarks. The anthropological assumptions that are made that underlie and animate and enliven the arguments in this domain are premises about what it means to be a person, what's important about persons, not in the sense of prenatal versus postnatal, although that certainly plays a role in the assessment, but rather what a person is, what's distinctive about a person, and what constitutes human flourishing. And what I hope to do this evening is to show, after I offer you a brief account of the domain of public bioethics, just to sort of set the table to let you know what it is that we're talking about, I'm going to offer a survey, a very brief, necessarily brief survey, of a series of questions, a series of disputes in this domain, and to examine the arguments in favor of abortion, contraception, embryo-destructive research, and assisted reproductive technologies, to try to uncover, unpack, drill down, and identify those embedded anthropological premises that do the work of animating the arguments in this field. And hopefully that will first have a clarifying effect on the discourse. We'll have a better understanding of what is at bottom driving the discussion. And it'll also put us in a stronger position to assess the arguments and, if we're so inclined, to mount responses to those arguments. And then in conclusion, I'm going to offer an alternative set of anthropological premises to those that undergird these arguments in favor of these techniques and practices that I believe are more fully human, they're richer, hopefully more appealing. And we'll set them alongside one another, the two different competing approaches, and then we can have a conversation about which one looks more humanly recognizable and coherent to us. So, let me begin. I'm a lawyer, so I have to start with a caveat, right? The caveat here is I'm taking arguments, and obviously we have a limited amount of time here and a limited amount of space. I'm taking arguments in favor of these particular arguments in favor of contraception, assisted reproductive technologies, abortion, embryo research. Particular arguments that are advanced by some of the most important voices in this area, some of the thought leaders, as they're sometimes called, both in law and public policy as well as theory. Obviously, there are many different arguments in favor of these practices, and there's no time to examine all of them. We can talk about the other arguments, the unmentioned or unstated arguments, if you like. But for the sake of argument, I've singled out particular claims that are being made to try to drill down and uncover the anthropological premises that underlie them. In some cases, I'll name the thinkers who I'm responding to. In other cases, I won't. To some of you, it might be clear. We can talk about it again in the question period. But in the course of my remarks, you might say to yourself, well, there are other arguments in favor of these propositions that are not being explored, and of course that's right, and we can do that in the question period, but for the sake of argument, for the sake of my case this evening, I'm taking what I regard as the most prominent and forceful claims made by the most prominent and forceful thinkers. So, let's start with the basic question of what is public bioethics? What is this domain that we're talking about? Well, first of all, we're not talking about merely a field of inquiry, a field of scholarly investigation. We're talking about governance. We're talking about a species of law. We're talking about the governance of science, medicine, and biotechnology in the name of ethical goods, not merely the ethical deliberations that arise in the face of advances in biomedical science and biotechnology in the practice of medicine. We're talking about the work of legislatures. We're talking about the work of judges. We're talking about the work of the executive branch, whether you're talking about governors at the state level or the President of the United States. Public bioethics is the governance of these areas of human activity in the name of ethical goods. Now, public bioethics emerged in the United States in tandem with bioethics as a field of scholarly inquiry. As a field of scholarly inquiry in the late 1960s, early 1970s, there was a sort of moment in which it was perceived, maybe rightly, maybe wrongly, that the practice of medicine had become detached from the humanistic dimension of that field. That is, the technical acumen that was being developed at an extraordinary pace because of advances in the sort of the bioscience revolution, the discovery of the structure of DNA, different work in pharmacology and the like, that doctors began having extraordinarily successful outcomes. and their techniques were improving at an extraordinary rate. But at the same time, as their role as technicians increased, it was perceived that their role as sort of humanistic partners in health with their patients and with the families to which those patients belong was not keeping the same pace, and that doctors were looking at their patients more and more as if they were objects to be worked on in a technical way, rather than fellow human beings to be almost ministered to in a sort of priestly way, which is the ordinary, which had previously been a fair description of the role of the physician. In any event, this disconnect led to a great deal of consternation and reflection both by physicians and theologians and scientists and philosophers and legal scholars, and many different conferences were convened, one of which happened at Dartmouth, where Dr. Tenney sort of summarized the crisis that gave rise to the birth of this interdisciplinary field, or at least area of scholarly inquiry, domain of scholarly inquiry of bioethics. He said, medicine's foundations have become more rational. Its practice, the welding of science and humanism, is said to have become more remote and indifferent to human values. And once again, medicine has been forced to remind itself that it is often the human factors that are determinant. So you had the Hastings Center up in New York was founded. The Kennedy Institute of Ethics was founded to study the questions, mostly in the clinical setting, of the relationship between ethics and the practice of medicine. Around the same time, there came to light certain very significant controversies, some involving the use and destruction of unborn children, involving fetal experimentation in the context of abortion, captured the imagination of certain members of the Kennedy family, who influenced their relative, Edward Kennedy, to convene hearings on this question in the early 1970s on the question of fetal tissue research and certain kinds of ethical questions that emerged in that context. So it became a public question, not simply an opportunity or occasion of scholarly reflection, but a public question. At the same time, it came to light the abuses of the researchers, the federally funded researchers, federal employed researchers in Tuskegee, Alabama, who conducted a natural history study of syphilis, wherein they were openly misled the very poor black farmers in that part of the world, my part of the world, Alabama, and told them that they were simply concealed from them that they were studying the progress of syphilis in these patients, didn't tell them that's what they were doing, and then when antibiotics became available in the 1940s and became standard practice for treating it, they didn't deliver antibiotics to these folks. They simply observed the progression of the disease, and they told themselves that they weren't doing any harm because these folks, given their socioeconomic circumstances, wouldn't have gotten the antibiotics anyway. So they weren't making the situation worse. They were simply observing the natural progress of the disease and trying to vindicate that tragic situation by gathering useful knowledge. That position was rejected, in my judgment rightly so, and gave rise to enormous controversy, which also formed the basis of these congressional hearings in the 1970s, which gave rise to the National Research Act, which created the National Commission for the Protection of Human Subjects of Biomedical and Behavioral Research, one of the forerunners of the President's Council on Bioethics, in which I served. And this commission, and it's extraordinary to think about what they were charged with as a matter of law. They were charged to, quote, identify basic ethical principles that should underlie the conduct of biomedical and behavioral research involving human subjects, that's in response to the Tuskegee situation, and to develop guidelines that should be followed in such research, and to conduct a, quote, comprehensive study of the ethical, legal, and social implications of advances in biomedical research. So they were, in effect, charged with a legal mandate to do bioethics in the name of the federal government with the coercive authority of the federal government behind them. The act directed the secretary of what was then called the Department of Health, Education, and Welfare, now called the Department of Health and Human Services, to implement their advice within a stated period of time or to show cause why action was not taken. And this was the birth of public bioethics in America. And since then, issues in public bioethics have roiled the public square. Issues, and this is just to take a handful of the issues, protections involving human subjects, contraception, embryo and fetal research, assisted reproductive technologies, cloning, abortion, and so on and so on. And I've highlighted in red the issues that we're going to be focusing on today to examine the most potent and well-known arguments in favor of these practices, to drill down to their core to determine what anthropological assumptions are driving those arguments. But before we do that, I'd like to make a case for the proposition that the law is a very useful mechanism to ask deep normative questions about what a given polity or culture cares about. Okay, people say, what's a lawyer? Why are lawyers interesting or helpful? Don't they just cause problems? Well, yeah, we do cause some problems. Sometimes it's good to cause problems. But in any event, the law is a valuable tool for this kind of inquiry into the goods that a given society embraces and the harms that they seek to avoid, because the twofold nature, pedagogical nature of the law. On the one hand, the law reflects the goods that people hold dear and the harms that they seek to avoid. The law has a reflective function, an informative function. It tells you can learn a lot about what a given society cares about by examining the law. Oliver Wendell Holmes, who is not generally a person that I cite in favor of bioethical propositions, or any moral propositions for that matter. It's funny, sometimes you'll get well-meaning people who will have an Oliver Wendell Holmes quote, like an innocuous, like, if you can dream it, you can do it. We can leave that. And I'm like, no, we can't put Oliver Wendell Holmes as the leading quote for our Notre Dame Ethics Center. In any event, he was right when he said that law is the witness and external deposit of our moral life. It does, in fact, it's a certain sort of preserved record of the things that we care about. But it also has an informative and shaping function as well. That is, another justice of the Supreme Court, Louis Brandeis, said that law is the omnipresent teacher. It shapes public attitudes, for better or worse. It shapes public attitudes about goods and harms. Many people take their bearings about right and wrong for what is legally permitted and what is forbidden. And the law is a valuable and very fine-grained instrument for conducting inquiry into what a given society cares about or should care about. And it's fine-grained in that the law doesn't merely, when you're examining the laws of a given society, law is not simply a binary yes or no. It's not prohibited or permitted. Law is, there's a wide spectrum of regulatory activity that's possible, each of which has its own sort of moral meaning, which matters a lot in the context of public bioethics. So, for example, the law can offer an affirmative endorsement and encouragement, not merely permit, but actually actively encourage, as in the case of federal funding. And that's really at the heart of the question of federal funding for embryo-destructive research. What does it mean for the polity to use its scarce resources to promote and encourage this kind of activity? The law, moving from the most permissive to the least permissive end of the spectrum, can offer silent permission, which is a kind of neutral tolerance, which is the default rule in our country in the absence of regulation. The law can grant permission with surveillance, signaling caution. For example, data collection in the field of assisted reproductive technologies, which is all we have in the federal level in terms of the regulation of ARTs. There's virtually no regulation of ARTs in the United States, which makes us unusual in the developed world. The law can grant permission with conditions, that is, through licensure and certification, which is how medicine is regulated in the United States. We don't generally have a regulatory body that regulates the practice of medicine. What we do is we certify and license people at the front end, and then for the most part, medicine is regulated through litigation, through medical malpractice litigation, and also through pressures brought to bear by the different professional societies and disciplinary hearings. But those are not those are private activities. Those are not public activities. The law can prohibit, but then carve out certain exceptions, as that's the primary framework within the FDA. The FDA regulates drugs, devices, biological products in this way. They forbid the use in interstate commerce of regulated articles, except wherein there is a special new drug application granted. And then finally, at the most extreme end of the spectrum, you have criminal prohibition, which is that signals the most draconian and serious kind of approbation for a particular area of activity. And in the context of public bioethics, human cloning bans, which are in place in certain states, not at the federal level, are a good example of that. So law doesn't, you can learn a lot from examining the law of a given society, and it's a very fine-grained way to understand the moral conclusions. It's hard to sometimes recreate what produced these results, but to examine the moral conclusions that a given polity has reached through its legislative bodies. So let's talk then about the issues that I began with: contraception, assisted reproductive technologies, abortion, embryo-destructive research, and examine the most, in a cursory way, given time, the most potent arguments in favor of these practices, and then ask ourselves, what is driving this? What vision of the person, what vision of human flourishing are driving these arguments? We have to start in back in the 1960s and 70s, there was a confluence of scientific, legal, political, and cultural developments that really shaped public bioethics in America, and also took their bearings from and shaped and were responsive to the arguments that we're going to be examining. we saw in the 60s and 70s radical challenges to the essential categories of human life. We saw radical challenges to the nature and meaning of human procreation, and we'll explain why all this is the case momentarily. We saw radical challenges to the identity, worth, and definitional boundaries of human persons. We saw radical questions posed about what parents owe to their children. And we were presented with radical questions about the true ends of scientific inquiry and medicine. What developments am I talking about? What events gave rise to these challenges? Well, let's start with 1960. In 1960, the FDA approved oral contraceptives and transformed our life as we know it. Very shortly thereafter, the public was responsive, the public sector, that is the courts, the federal courts, and were responsive to claims on the part of individuals that there was a constitutional right to contraception embedded in the language, not specifically stated, but embedded in the language of the various amendments and the emanations and penumbras in the seminal case, the Griswold versus Connecticut case. There's no specific right to privacy mentioned in the U.S. Constitution. However, the justices of the court, a majority of the justices of the court, inferred a right to privacy from the constellation of rights that seem to touch and concern intimate matters, the Fourth Amendment, right against unreasonable searches and seizures, the Fifth Amendment, right against being compelled to be a witness against yourself in a criminal trial, the right to free expression, the right to free association. They said all of these taken together, if you can induce a right to privacy that can be vindicated against the government, against state action. And in this area, with respect to contraception, in 1965, the court said it is unlawful, it's unconstitutional. It's an unconstitutional breach of the individual's right to privacy that is implicit in the Constitution and the Bill of Rights to prohibit the sale of contraceptives to married couples, 1965. Very shortly thereafter, in a case called Eisenstadt v. Baird, the court declared it unconstitutional to prohibit sales of contraceptives to unmarried persons. And then 5 years after that, in a case called Carey versus Population Services International, the court said it was unconstitutional to prohibit the sales of contraceptives to minors. Now, the arguments in favor of contraception, and obviously being at Catholic University and with the sort of the backdrop of all the disputes and argumentation about contraception that occurred among members of our church and others, let's put that to the side for the moment and focus on and distill the argument in favor of contraception, the normative argument in favor of contraception, as you can see now in our modern era, is the notion that contraception is an essential mechanism of liberation. Now, these are real ads, okay? In fact, I was on an airplane this morning, and a woman next to me was reading People magazine, and I know it's rude to read over people's shoulders, but she opened it up, and it was a full-page ad of this ad right here, okay? Now, look at the ad, and it's important. Obviously, fundamentally, the argument here is that there's freedom to pursue one's plans and priorities, and the freedom to procreate or not procreate as one sees fit. But notice how the case is made, visually and rhetorically. This says, "This is my baby right now," says the ad. And you see the children's slide, and coming down the slide is a cello. And my son was like, "Is there a kid at the top of the thing that threw the cello down the slide?" No. In fact, the idea is the cello is the baby. This is my baby right now. This hobby, or maybe she's a professional cellist, this job is my baby right now. This is my choice. This is my project right now. Down here you see the exact same thing. This is a very expensive camera on a tripod. This is her baby right now. So you don't have her speaking of some third person describing the situation on the beach pushing the tripod. And this is her baby right now. So the argument implicit in the imagery and in the rhetoric is the idea that contraception is a mechanism, an essential mechanism of liberation for women to pursue the life that they would like to pursue, the forms of life that they would like to pursue. Now, this argument has played out in a dramatic fashion since 2011 with the dispute over the so-called contraceptive mandate. I say so-called because it doesn't just include contraceptives. It also includes drugs that can cause the death of embryos pre-implantation and possibly even post-implantation. So you can fairly call it an abortifacient contraceptive sterilization and counseling mandate. This is Sandra Fluke, graduate of my law school, Georgetown. And this is, of course, the other side. And if you look carefully, I'm going to embarrass her, but right there is, where's Arena? There you are. This is from the New York Times, and there she is, right there. How about that? Graduate of Notre Dame. You got Georgetown and Notre Dame. So anyway. Sorry, Gene. So we've talked, so 1960s, you have the approval, the FDA approval of oral contraception. 1968, you have Steptoe and Edwards in their academic regalia, who achieved for the first time in human history the in vitro fertilization of a human egg. That is literally in glass fertilization, the conception of a human being outside the body in a petri dish. Here you see, this is a human being at the embryonic stage of development. And for the first time ever, it became possible literally to hold and behold, as my mentor Leon Cass said, the human being outside the body, previously mysterious, hidden inside the woman's body, even before you could detect his or her presence. And I say his or her because this baby has sex at this moment. This is a male or a female. Can't tell from the picture. Maybe somebody schooled in the sciences can tell. And this moved procreation from the home, from the marital, from the man and wife together in the sexual act to the laboratory, right? So you have technicians examining the embryos. You have cryopreserved embryos. You have multiple gestations because of the way IVF is practiced. And of course, Louise Brown was born in 1978, the first child born from IVF, which sharpens and focuses our attention on the fact that what we're talking about are babies. We're talking about living human beings at the early stage of development. And in fact, in a sort of, I don't know if it was an unguarded moment, or if he just didn't care, but I think it was Steptoe or Edwards. One of them said, I saw Louise Brown in the Petri dish when she was just an embryo, and I saw her when she was born, and she was beautiful then, and she's beautiful now. So the continuity of the human person across stages was even evident and irresistible, and he couldn't even avoid observing himself, Steptoe and Edwards. With this brought about new possibilities to manipulate and instrumentalize human life, things like genetic selection, human cloning, which quickly gave way to sex selection. Now, sex selection has been practiced for a very long time with infanticide, and then ultrasound and abortion. In the context of assisted reproductive technologies, it's practiced under the heading of family balancing, where they can identify male versus female embryos, and in almost every circumstance they transfer the males and discard the females. So this is another possibility, not just a possibility, but a reality that has emerged as a result of the practice of assisted reproductive technologies in the United States and around the world. And this gave rise to an entire industry, a eugenic sort of industry of selecting traits using pre-implantation genetic diagnosis. Sex selection is a kind of rough eugenic intervention, but you can become even more sophisticated and fine-grained using things like pre-implantation genetic diagnosis. And of course, human cloning is another rough form of genetic engineering, where you produce a genetically virtually identical organism, or a human being that is genetically virtually identical to a pre-existing individual. And then you also see, as a result of the IVF revolution, the baby, the unborn child, and then even in some cases the born child, being treated as an article of commerce. Now, this couple from Australia, you probably read about them. This is baby Gammy right here, and this is the surrogate that they paid to carry baby Gammy to term. And baby Gammy's twin was healthy. Baby Gammy, as you might be able to tell, has Down syndrome, and this couple thought that they didn't bargain for that. That wasn't the thing that they were trying to. That wasn't the deal they had. This violated some sort of warranty that they had in mind, and therefore they would not accept baby Gammy as their child. And thankfully, the surrogate has. I think I haven't been following it that carefully. I think the surrogate has decided to rear the baby. But ART, as practiced, creates the possibility, and in this case, the reality of the individual human being understood as a kind of article of commerce, a thing to transferred, bargained for, and exchanged. And of course, in the context, as I mentioned earlier, in the United States, assisted reproductive technologies are not regulated. other than a very weak federal provision that provides for data collection and publication, which is underfunded and in fact is only a snapshot of what goes on and the sorts of things that are reported. It's called the Fertility Clinic Success Rate and Certification Act of 1992, and it doesn't do very much. If you'd like to read more about that, you can read the report Reproduction and Responsibility, which we produced at the President's Council on Bioethics. It's available online. But at the international level, IVF, assisted reproductive technologies, has been declared a human right. The Inter-American Court of Human Rights in Latin America and North America, for that matter, declared Costa Rica's ban on IVF a human rights violation just 2 years ago. Now, the normative arguments that one encounters, the most prominent defender of the maximal right of access to assisted reproductive technologies is a professor named John Robertson. He's from the University of Texas. He's a very eminent law professor. For many, many years, he was the chair of the most important professional society for assisted reproductive technologies, ASRM, the American Society for Reproductive Medicine. And his argument, he wrote a very big book called Children of Choice, and makes the case that there is a right to procreation, and the source of the right to procreation is the importance that it has to the individual who bears that right. That is, the choice to pursue or avoid procreation, according to Professor Robertson, is essential to self-definition, pursuit of desires, and self-expression. That is the source of the right itself. Now, that's an interesting, as a theoretical matter, it's interesting to locate the source of a right in one's desires, the individual's desires. That's an interesting, we could talk a lot about that. But just for the sake of argument, I will put that out there and you guys can focus on it, and we can circle back in a minute and try to unpack what's going on there. But Professor Gerald Shatton, who is a scientist and a physician at the University of Pittsburgh, testified before the President's Council on Bioethics. When I was there, I was sitting in the room, and he was asked directly, what do you think the goal of assisted reproductive technologies are? And he said, and this is clearly something he thought about and had said before and was well rehearsed, and I don't mean that as a criticism, I just mean to say that he had thought it through. He said the goal of assisted reproduction is to, quote, help parents realize their dream of a disease-free legacy. That's his reflective, focused explanation of what ART is for. That's what it's for, to help parents realize their dream of a disease-free legacy. And so we should ask ourselves, what is the child in this picture? If what we're focusing on ultimately are anthropological questions, what a person is, what's human flourishing. Let's ask ourselves, a central player in this drama of assisted reproductive technologies is the child to be, or the child in being. What is the child in this picture? The child is the child, and I'll pose these as questions, not as assertions. Is the child, given what we've been talking about so far, merely a project? The object of the parent or parent's will? Is the child merely a vessel into which the parent or parent's aspirations for a disease-free legacy, for example, are poured? Is the child a product to be accepted or rejected to the extent that it matches parent or parent's desires, as baby Gammy was? We'll come back to that. So we've talked about contraception, assisted reproductive technologies, the arguments, the prominent normative arguments in a very sort of cursory fashion in the interest of time. Let's talk about abortion. I can't resist pictures of kids from Notre Dame doing good things. This is the Notre Dame contingent at the March for Life. 600 students, the March for Life, largest contingent of any college or university. Here are some people who are in favor of abortion rights. I found a picture of them as well, so I wanted to have equal time. So there's a picture there. It's a very appealing photo. The context of abortion, let's talk about, it began in the United States, sort of, or it reached its fever pitch. Again, late 60s, early 70s, 1973. Roe versus Wade. Everybody's heard of Roe versus Wade. The law at issue, of course, was a Texas statute that banned abortion except in cases where continued pregnancy posed a threat to the life of the mother. Now, the court's holding, in summary, is a very long and complicated opinion and touches and concerns a very complex and controversial area of jurisprudence called substantive due process. We can talk about it if you want to. But the bottom line here is that the court said laws restricting abortion implicate an unenumerated, that is unstated, unspecified, implicit but fundamental right to privacy that is implied by the Due Process Clause of the 14th Amendment. This opinion was built directly upon the jurisprudence of contraception. It was built directly upon and depends directly upon Griswold versus Connecticut and subsequent contraceptive cases, which articulated for the first time the idea that there was a right to privacy that related to the decision to beget a child. And then Justice Brennan later added to bear a child. And this came to fruition in Roe versus Wade. So, in some ways it's troubling because the right to privacy was built on very old cases in Griswold, very old cases that related to the right of parents to educate their children, the right for people of different races to marry one another, issues relating to the dignity of intimate relations, family, children, child rearing, and those sorts of things. The idea that the Constitution protects those relationships, that became the foundation to extend the principle of substantive due process and the right to privacy to contraception, and now the right to terminate pregnancy, to kill an unborn child in an abortion. Now, Roe versus Wade was 1973. A lot has happened since Roe versus Wade. That's a very long lecture. Some of you who attended my Vita Institute at the Notre Dame in the summertime, we can talk about that if you want, have heard this lecture. We won't talk about it. Let's fast forward to the present. What's the law of abortion in the United States? There is an implicit protected liberty interest. Notice, different word, not privacy, liberty interest in the abortion in the U.S. Constitution. Before viability, the state may not unduly burden a woman's right to abortion. Viability is the moment at which the child has a reasonable chance of living outside the mother's body. It's a function of lung capacity and access to technology. It's a shifting, contingent, standard, problematic for that reason, among others. After viability, the state can regulate abortion, but such regulations must be waived in any case where the abortionist declares that some aspect of the woman's well-being, economic or familial, those are words that are used in the relevant precedent here, are served by abortion. So that means there's a near absolute right to abortion throughout 9 months of pregnancy in the United States. The Supreme Court may or may not permit ancillary restrictions on abortion, such as parental involvement laws, informed consent laws, restrictions on certain kinds of particularly grisly forms of abortion, like partial birth abortion. And one thing to keep your eye on is there's a new emerging constitutional justification of abortion, not privacy, not liberty, but now it's equality. The idea that abortion is an essential mechanism by which women can realize their equality as citizens and to participate equally in the social and economic life of the country. That is, women have the right to engage in the same kinds of sexual practices as men and have the right to free themselves from the consequences in the same way that men can by walking away from their pregnant partner. But there's something to notice here. The case that is fundamental, that drives the question of abortion in the United States, the jurisprudence of abortion, is a case called Planned Parenthood versus Casey. And the line that you've probably heard before, and is quite important for the inquiry about anthropological premises, is this passage from Justice Kennedy. It's attributed to Justice Kennedy. It's certain that he wrote it. It comes out of the three-justice plurality. It was the judges took three of the justices, Kennedy, Souter, and O'Connor, took different parts of the majority opinion. He wrote this part. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. This is the concept, the normative concept, that drives Justice Kennedy and prevents him from overturning what he calls the core holding of Roe, or at least so far has prevented him from doing that. We'll come back to that. So what are the normative arguments? We distilled the normative arguments for abortion. What are they? One is the unborn child is not a person because she cannot formulate and pursue future-directed goals and projects. There are a lot of people who have made that argument. Martha Nussbaum makes that argument. Tooley, Boonen. There are a lot of people who have made this argument. Personhood is defined by the capacity to formulate and pursue future-directed goals and projects, or at least to appreciate them, at least to appreciate the fact that you are an I that can do that. And they think that because the child is cognitively not capable of that the child is not a person and therefore doesn't have the protections and rights that persons do. The other argument, and this we can call that the sort of personhood argument for abortion. The other argument, these arguments are sometimes made in combination, sometimes made separately. Second argument is a kind of bodily dependency argument. Namely, the unborn child burdens and prevents her mother from freely and equally constructing her chosen future. This is a kind of way of describing Judith Jarvis Thompson's argument in defense of abortion from 1973. The child is a burden. The child is an invader. The child is an other that is obstructing the woman's chosen pathway. And related to that, the mother has no obligation to the unborn child. And this is really Judith Jarvis Thompson. The mother has no obligation to the unborn child because she didn't choose to conceive and or bear the child. There is no choice, there's no consent, there's no obligation. Okay? And consent can be revoked at any time. Those are the normative arguments in a nutshell. How about human embryo research? As I said, IVF, among other things, created a new demand for embryos for use and destruction in research. In 1998, this sort of reached a fever pitch with the isolation of human embryonic stem cells at the University of Wisconsin by Jamie Thompson, right there. Hopes for path-breaking regenerative therapies, the capacity to have your biological repair kit, as Ron Reagan Jr. said at the Democratic National Convention in 2004, inflamed the imaginations of people who had loved ones who they cared about very much, who they wanted to stop their suffering. And they're very sympathetic individuals who are suffering from dread diseases like Parkinson's and debilitating injuries. And the desire for cures for these folks was very strong indeed, and understandably so. On March 9, 2009, President Obama announced for the very first time in American history that he would adopt a federal funding policy that created incentives for the use and destruction of living human beings at the embryonic stage of development. That the United States government would put its prestige and authority and money behind the project of embryo-destructive research, including the creation of embryos solely for the sake of research. Now, the normative arguments for promoting embryo research will be familiar to you. The embryo is not a person for the very same reasons that the unborn child in utero is not a person. Incapacity to formulate and pursue future-directed plans. Scientists should have robust autonomy to pursue knowledge without significant constraints, so long as they're not hurting persons. And then also, individuals who are suffering from debilitating diseases and injuries should be freed from those constraints of disease to pursue their future-directed plans. Lives unburdened by dread disease and injuries. And that's on its face, that's a very powerful argument. So, we've talked about, albeit in a compressed way, contraception, assisted reproductive technology, abortion, embryo-destructive research. We've sketched out the public policy. We've given a very distilled account of the most prominent normative arguments and legal arguments in favor of these practices. So in light of that, what exactly are the anthropological premises that drive these arguments? What are they? What is the person? And I would argue that the common thread running through all of these practices, every single one of the arguments, trades in a kind of image of the person as a radical individual. Atomized, separate, antagonistic, alone. Person is a unit, is a monad, is an atom, exists by him or herself, not necessarily connected to anyone. The person is a will. What matters about persons is their will. What matters about persons, what defines a person, is the content and capacity of your desire. This is an image. This is a René Descartes diagram, if you didn't know that. What matters is what I want, what my project is, and my body is an instrument to pursue those goals. There's no necessary connection between mind and body, except insofar as my body is an instrumental tool that I can use to pursue the goals that I choose. And what makes me, what defines persons, what makes persons distinctive and important and interesting, is their capacity to choose, is their capacity to see the world and to construct their own projects make choices, yes to this, no to that, yes to the cello, no to the baby, and so on. And social relationships in this frame are also driven by this concept of individualism. As I've said several times now, the height of human flourishing is the unfettered, unobstructed construction of projects of your own choosing. Freedom, the assertion of the unencumbered self, is the highest good and the most important form of human activity. There are no natural restraints on will or desire. This is, maybe you've never seen this. This is literally a tabula rasa, this picture right here. Have you ever wondered what that looked like? That's what it looks like. There are no natural ends that confine our desire or our will. There's no teleological structure that orients what we can and can't do. Personal relationships are instrumental and contractual. You come together with other wills in this space, right? In the social space, you come together, one will to another will. You come together to form a project of mutual benefit. As long as it's beneficial, you come apart when it's not, when it's no longer beneficial. What matters is consent. What matters is agreement. And there are manifestly no such thing as unchosen obligations. No one has a claim on me without my agreeing to that arrangement. And I don't have a claim on anybody else absent some meeting of the minds. And persons in this frame are, in, I think, a significant way, considered isolated adversaries clad in the armor of their rights. The universe of ethics becomes compressed, and autonomy becomes the highest good to which all other goods are subordinated. And you can see this in the most influential writings in public bioethics, Beecham and Childress, the Georgetown principles. Obviously, they have 4, sometimes 3 principles: autonomy, justice, beneficence, and or non-maleficence. But the one that gets traction in our pluralistic culture, the one that really rises to the top and subordinates the others, is autonomy. It's true in Ruth Macklin's work, it's true in Steven Pinker's work, it's across the board, it's evident everywhere. And injustice becomes primarily understood as constraining the freedom of others to pursue the projects of their own choosing. And the role of government in this frame is primarily to remove constraints, public constraints, private constraints, natural constraints, and to otherwise provide the conditions for the assertion of the unencumbered individual self. So in sum, the public arguments for abortion, contraception, assisted reproductive technologies, and embryo-destructive research reflect the following understanding about persons. Persons are conceived as autonomous individual wills. And by the way, the corollary of this is if you lack the capacity to formulate and pursue projects, then you are a non-person. Unborn children, the cognitively disabled. If you can't choose, you don't count in this framework. And if you doubted, and this runs throughout all of the literature defending abortion and in some of the judicial opinions as well. And the height of human flourishing, as I said, is the creation and pursuit of future-directed plans. The world and others are instrumental means to achieving one's desires. The desire for freedom, as in contraception and abortion. Desire for health, most broadly understood, as in embryo research. Or for an idealized family, in ARTs and PGD. And the only binding obligations in this space are those that we choose. Children and family are understood through the lens of will. They are a project, freely chosen or rejected, as the family in Australia did, the baby Gammy, for our own ends, sometimes with the aid of technology. Now, that, I think, is the normative grounding that animates and drives all of these different theoretical and public arguments. And we should ask ourselves when we get a moment, how does that look to us? Is that recognizable? Does that feel right? Does that seem like a human-shaped life? Does it, when we see our family and our children or our grandchildren, does that resonate? I would argue no. We can talk about that. We can have a conversation about that. And I think it's important to set alongside those anthropological premises and those arguments an alternative. An alternative that's also embedded in a lot of the public arguments against these practices and techniques. An alternative to the radical individualism of this domain. I'd like to make a case or to provide or suggest an alternative frame, and it's just the beginning sketch of a frame, for a richer understanding, in my judgment, of personhood and the common good. This richer conception of persons and human flourishing, I hope and think, will be an attractive alternative that should drive our thinking and our choices and our governance in this area. So what's an alternative vision of persons to the radical, individual, atomized, antagonistic chooser of projects? It's a capacious concept of equality and human dignity. That is, every human being, regardless of his or her capacities, of circumstances, of the burdens that he or she imposes on others or doesn't impose on others, the lack or possession of certain favored physical or mental capacities, and certainly the worth assigned to her by others, every human being is valuable, irreplaceable, and equal in basic human dignity in virtue of who she is as a living member of the human family, from conception to natural death. And the corollary of that proposition is that it's morally incoherent and, in fact, a grave injustice to exclude from the circle of persons in the protection of the law those who are immature, small, dependent, or incapable of high-level cognition. It is a tyrannical imposition of the will of the powerful on the weak and vulnerable to indulge in an alternative point of view. And just to underscore the point, in this framework, there is no such thing as a human non-person. There are no pre-personal human beings, embryos and fetuses. There are no post-personal human beings, those who are cognitively disabled. All human beings are persons from conception to natural death. And in this framework, there is a manifest rejection of the kind of inequality that is embedded in the prior anthropological framework that we were discussing before. The arguments for contingent personhood that we sketched out earlier invert our best moral traditions. They effectively privilege the claims of the strong over those of the weak. Those frameworks for contingent personhood that erect tests and standards that if you meet it, you're a person, if you don't, you're not a person, they produce monstrous practical results, including, for example, a sliding scale of moral and legal standing for people based on their cognitive ability, usefulness, and strength, and so on. The framework that I'm proposing takes its bearings from Hans Jonas, who said that utter helplessness, to the contrary, demands utter protection. So that's the vision of personhood. Again, it's a sketch. I mean, we only have a certain amount of time. But that's a vision of personhood that I would set alongside the vision of personhood that we began with in the form of radical individualism that animates the arguments in favor of those techniques and practices. So what is human flourishing? What's a different version of human flourishing from a universe of individual wills coming together in contractual relationships when it makes sense and breaking apart when it doesn't? It's a conception we set alongside it that is best understood as, in the Catholic tradition, the language we like to use is the common good. What persons owe to one another. We come into the world not as isolated individuals, but rather we come into the world situated in relation to others. We have connections of kinship to past, present, and future generations. We do not come into the world unconnected to other members of the human community. So this counsels in favor of strong principles of solidarity and community. And also taking seriously the concept of vulnerability and understanding that there are, in fact, unchosen obligations. And to reject the substance dualism of the anthropology that pushes in favor of these practices. We don't emerge as disembodied wills. We emerge as profoundly vulnerable and needy, embodied living organisms. From the very beginning, we rely on the beneficence of others for basic survival. And as a result, we owe a reciprocal duty of care to all members of the human family, including especially the weakest and most vulnerable among us. And what I hope we can do with this alternative framework, this alternative approach, this sort of richer, anthropological, dignitarian, common good-driven alternative anthropological frame, is to cure the problem, the failure of the moral imagination that I think is at the root of most injustice in the domain of public bioethics. That is, I think that the evils, and I'll call them evils, of abortion, embryo-destructive research, assisted reproductive technologies, and on and on and on, are driven by the failure or refusal to recognize the unseen other as one of us. It's the failure of parents to recognize their child. It's the failure of a doctor to recognize his patient. It's a failure of our society to recognize one of its members. It's more radical. It's a more radical failing than the failure to love our neighbor as ourselves. This is the failure to recognize our neighbor as a fellow human being. And we're familiar with this. The more distant an individual person is to me, the more distant a suffering person is for me, the less of a claim I feel intuitively in my heart. The children who are starving in Africa, people who have suffered an earthquake in Haiti, the homeless people in the streets of South Bend, Indiana, or refugees from the many wars that are besetting our globe right now, these people are far away from me. I think about them for a second, and then the next thought is I got to pick my son up from school or whatever, go to soccer, right? It's my failing. It's a failure of moral imagination. It's a failure, and we see this in a dramatic way in the context of public bioethics. We look at a human being, we look what you and I look like at this stage of development, this stage of development, this stage, and perhaps later we'll look like that, and we don't see ourselves, we don't see someone who has a claim on us, whether we like it or not. So, let me finish by saying that I hope, by focusing on the anthropological grounding of these arguments for and against these practices, questions about persons and human flourishing, we can clarify in our own minds what's at stake and what we believe and where the arguments lie. And we follow the arguments to their ultimate normative entailments and to their practical consequences as well. And again, as I said before, once we've considered in a comprehensive way, at the deepest level, what vision of persons and human flourishing are driving these claims, we have to ask ourselves, what's the most recognizable, intelligible, coherent, and human account of persons, our shared life together, the goals of science, the ends of medicine, and the fitting distribution of essential health care? So with that, I'll wrap up my prepared remarks and we can have a conversation. What's the process? Do we call on people or what do we do?
It's been our tradition with this speaker series that the moderator poses the first question and then we open the floor.
Okay.
So with that, let me ask you a question about public reason.
Yeah.
There's been a lot of ink spilled about what public reason is,
Yep.
which kinds of arguments are admissible in the public square.
Yep.
And it seems to me that the sort of Robertson, Kennedy / Casey line of argumentation is fully within the bounds of public reason.
Why would you say that?
Well, in the Rawlsian framework, okay, because they're not explicitly appealing to a comprehensive doctrine of the good, right? I would argue that
aren't they?
implicit.
Yeah.
Oh no,
Yeah.
absolutely. I would
Yeah.
take your side on this. There is implicitly a comprehensive doctrine of the good.
Yeah.
Being referenced there, even if it's implicit. With the alternative that you're sketching, it strikes me that contra Kennedy, you would suggest that the meaning of solidarity, the meaning of interdependence, is something that is independent of individual cognition and will and desire, that somehow we receive meaning, that in the first place we receive the world, indeed as we receive our own existence. Does your alternative vision depend upon a transcendent frame of reference, transcendent origin and destiny of the human person? And if so, is that admissible in the public square?
I would say this way, and this is in some ways a lawyerly answer. I would say my vision depends on a comprehensive view, metaphysical premises, no more than theirs does,
Okay.
right?
Yeah.
That is to say, I think that any ultimate claim about any normative ethical principle is in fact it suffers, I don't think it's a problem, but under Rawls's view, it suffers from the same problem, right?
Right.
That is, if I talk about human dignity and Steven Pinker and Ruth Macklin say, well, what is that? That's a useless concept. It's an empty concept. I can fill it with whatever I want to. I can argue in favor of assisted reproduction or against assisted reproduction based on this principle. I can say the exact same thing about autonomy. I can say the same thing about justice. I can say, from whence does this liberty come? Well, why do I have rights to, what's the substance, source, and contours of the thick normative principle that you're wielding against me in this argument about privacy or liberty or equality? Equality is the most relational of all of them. I mean, I could honor equality by treating everybody equally badly, right? But what I like, the reason I'm optimistic in the public set. Now, this is the difference between an academic argument, a theoretical argument, and a public argument, right? If we're philosophers, and I see philosophers in the room, and we say, well, how do you, and David Solomon makes this point, and I think he's right, that you can come to an impasse very quickly with your discussant or your opponent in an argument. You drill down very quickly to what first principles you have, and then you don't agree, and then they're incommensurable, and then you sort of go your separate ways, right? And that's as far as you can get. In the context of philosophy and philosophical discourse, I think that's probably right. I mean, I think that there's no way for me to argue into submission a person who disagrees with me at the root of first principles. But the good news is that I'm a lawyer and not a philosopher, and that means that at the end of the day, you make your argument, I make my argument, and we vote, right? And so I say, you know, are you not entertained at the end of my argument, right? That is, the point is, and I'm not being cynical about this, but the bottom line is, in our form of government, the way it works is, and the court is not going to say my arguments about human dignity are out of bounds any more so than they're going to say arguments about justice, substantive due process, equality, which are equally ambiguous in terms of their source and content as dignity and everything else. It's all thick ethical principles that we're arguing about. And the good news for public policy, and this is the difference between governance and academic discourse, is at the end of the day, people get to listen to what I'm saying and ask themselves, what's more human, right? Which account looks more to me? And that's why culture matters so much, right? That's why the work of persuasion it depends on cultural signaling, cultural transformation, beautiful art, beautiful plays, beautiful novels, trying to change hearts and minds in ways, sort of the Harriet Beecher Stowe moment where you can paint a picture for someone in a way that you couldn't in an argument. This is just a sort of tableau of human experience to shape hearts and minds. That's the good news about our public square. It's not the case. I'm not forbidden under any reasonable construction of the First Amendment jurisprudence from making arguments that are explicitly Catholic in the public square. Now, I'm not sure it would be a great idea in terms of persuasion, but the good news is nothing I said in this discussion is irreducibly theological, or at least any more so than arguments about liberty and autonomy, right? So I would say, my view is that we're all on the same footing, and the good news is the public square is robust enough that I can make these arguments. At the end of the day, people are going to make decisions. Now, you might say there's a deep problem with that, in that why should should the question of the boundaries of the human and moral community be up for a vote? Right? Now, that's a problem.
Right.
And I don't have an answer to that.
But it's a different problem.
It's a different problem. I play by the rules. You give me the rules and I play by the rules. That's what lawyers do. And so the bottom line is that I make an argument that is, and as I say, we don't have Rawls's rules of public reason that control our public square right now. And we shouldn't, and we don't. And that's the good news. Because I think Joe Mailander is right about this. At the end of the day, I'm not sure you can make an appeal to liberty, privacy, autonomy, dignity, justice, whatever, without sort of metaphysical presuppositions. Okay. But we don't get to that point in our public discourse. And whereas philosophers can argue back and forth, the good news is that people in the public square get to hear these kinds of arguments and get to govern themselves. Okay,
thank you.
That's
We're opening the floor. Christina.
That's not let me just, as a point of clarification.
Yeah.
That's the presumption of the role of government within the frame that I was sketching out. I don't think that's a fair rendering of what government's for, but yeah.
Yeah, no, that was essentially my question, though. Even if that is what they're claiming to do, couldn't you say that due to our current situation, the role of government in that sense is really to make space for publicly acceptable choices? Because it would seem that all those examples that you were showing us, contraception, abortion, those are all hot button issues that are, somewhat culturally acceptable.
Right.
Less
so polygamy or homeschooling.
Exactly.
Or whatever.
Well, yeah, exactly. Those are clearly on par, yeah. Yeah, and I guess that's essentially my question there, because it would seem that we have campaigns of all sorts. For instance, with obesity that we see now,
Right.
or taking
Smoking.
taking choices out of school lunches or things like that
right.
in order to make them more healthy. So could you say that is essentially the role of government, just to allow us to make those publicly acceptable decisions?
Yeah, no, that's an interesting. That's an issue of sort of hypocrisy and application, right? So what you have, I agree entirely that in practice, that's what it looks like. It's sort of totalitarian. Like if you want to choose the thing that the cultural elite think is something worthy of choosing, then we're going to wall that off and protect it. But if you want to pursue some sort of alternative life that is disfavored, then that's going to be But the way that is manipulated is under the sort of harm principle, right? Like they say, well, obviously the constraint on freedom is the moment you harm another individual. So you have to have a theory of personhood in order to get away from the harm principle on the question of abortion, because you have a perfectly consistent libertarian who's pro-life. There are many such people, and the idea is that abortion kills another member of the human family, and therefore it's off the table. But yeah, I think it's a good observation, an important observation that you make about how in practice it doesn't actually look as free as the principles might suggest.
Thank you.
So first of all, thank you for your presentation. My question, it picks up a little bit on what Dr. Schindler asked. You kept sort of calling what you were talking about public bioethics. And I guess I want to push you a little bit more. What does public mean? How is it distinguished from private? Is that helpful in the sphere of bioethics or culture for what I think you're saying we should be trying to do? So could you just...
Yeah, that's a great question. So what I mean by public bioethics is to distinguish it from simple scholarly reflection, right, or scholarly debate and inquiry, something that goes on that doesn't have concrete governmental purchase, right? That is, public bioethics is the governance of science, medicine, biotechnology in the name of ethical goods. And that can take place in a private scheme. Private tort law, for example, is a mechanism of governance. That's how we primarily govern the practice of medicine. I'm not talking about the public-private distinction in the sense of government versus non-government actors because in a funny way, once you're talking about litigation, there is no public-private distinction anymore, because at the end of the day, the court is going to vindicate the interest of one party or the other, and the coercive authority of the state is going to back that up. So what looks like a private dispute becomes a public dispute once the court gets involved. All I mean by the word public is we're talking about the field of governing, the work of courts, the work of legislatures, the work of members of the executive branch in the official, or for that matter, and you could call it private tort actions. That's public for purposes of this discussion because it involves the court. Does that make sense?
Yeah, just to follow up. So I guess then my follow-up question is, what does public bioethics have to do with what you might call private bioethics or?
Well, they're obviously connected in that the work of private bioethics, that is the work of scholars publishing things. Now, obviously, there's a sense or deliberating, and obviously it gets kind of fuzzy because the contributions they make become part of the public debate as well. So it's not a hermetic separation between public and private. What I'm really talking about is state action versus private reflection. But they're obviously connected to each other because those who are engaged in private reflection advise and influence the public actors.
Okay, this gentleman here.
Yeah, Carter, can we go back to the practical hypocrisy aspect?
Yeah.
Which is, thank you, by the way, for the presentation. It makes me question your fundamental hypothesis, which is that we're at there's a contradiction
Yeah.
between fundamental anthropologies.
Yeah.
What makes me question that is that the party, for instance, that has been so successful in prosecuting this notion of the radical autonomous individual is so disrespectful of that concept in alternative spheres of public life.
Yeah.
The president, to name a person, can rattle off the argument that you proposed is autonomous and then slip into the language of communitarianism whenever he wants to raise our taxes, or whenever he wants us to use a certain type of light bulb, or whenever he wants to give lawyers a cause of or
Right.
to create a cause of action
Yeah.
for what you sell at garage sales,
Yeah.
or whenever they want to do anything that they view as nudging you, in Cass Sunstein's terms, towards the appropriate outcome. They're tyrannical as they could possibly be. And I think they're perfectly well aware that whenever they trample on a conscience exemption, for example, or for instance, they're causing harms. They know people are being harmed, but there seems to be a statement, an implicit statement that, well, those people deserve to have harm done to them.
Yeah.
Because they have the wrong opinions. They're on the wrong side of these issues, and harming them is justified by some greater right.
Yeah.
And that greater right is not located in anthropology. It's almost like the anthropology you've outlined,
Yeah.
that it's been instrumentally used to great effect over the period of 50 years in Supreme Court jurisprudence. I just don't believe that's what's driving them.
Well, we'd have to take it issue by issue, but we focus on the conscience question. It seems to me that the argument that, at least the public argument that's made in favor of the HHS contraceptive abortifacient mandate, which is unbelievably tyrannical and forcing institutions like this one and Notre Dame and others to do things that are against their conscience, are made in the name of the autonomous choice and freedom of the individual employees who don't happen to share the same religious perspective as the... So the argument is framed as an autonomous, liberty-driven argument, and that's the argument that gets purchased with Anthony Kennedy, right? And that's what he was focused on. The question of who is harmed. Am I more sympathetic to the institution that has integrity issues and questions of, its sort of institutional integrity at stake and its capacity to bear witness to its most closely held and valued principles? Or am I more concerned about the individual liberty of those people who happen to work for that and they're being harmed by not having access to the benefit of this otherwise general law that everybody else gets access to? I don't think that people are incapable of adopting different anthropological postures in different moments, because insofar as they do both, what are we supposed to say about their actual point of view, right? I mean, they're collectivist on the one hand and tyrannical on the other hand. They use the rhetoric of radical autonomy. I think that when you want to, I suppose I would think, and this is an important challenge and something I have to think through, but I think that at the moment I'd be inclined to deal with it in a sort of modular way. That is, let's isolate the questions of public bioethics and deal with the rhetoric and the premises there. Then if you want to talk about, climate change and the sort of policies that are driven from concerns about that, or if you want to talk about, obesity, then we can talk about that. I mean, it seems to me that you could probably describe the whole scene in a way that relates to, basically the concept of harm just expands, right? And when you're talking about state action as a warrant for state action. Talking about smoking or whatever examples you want to give. But it seems to me clear that at least in the context of abortion and these other areas that we talked about, I do think they're serious about this concept of radical individualism. And it's important to make folks who are making these arguments own those arguments too, because at the same time they're going to be trying to hang that caricature around their political opponents and say, you are the Koch brothers, and you think everybody, this is just some kind of crazy free-for-all, law of the jungle, social Darwinism situation, and in fact, we're the ones that care about, community and family and connections and claims. And I think that, and so what I'd like to point to is those who are most aggressive in pushing the boundaries of these kinds of dehumanizing and destructive practices are adopting a pose of radical individualism, which I think is really what they. I mean, it's schizophrenic, but I think they do believe it. But it's a hard question, and it's something we should think about.
We've taken 3 questions from that side of the room. Let me
Okay.
go.
Thank you. Here at the Institute, the idea of human flourishing and the human person is closely tied to being male and female, man and woman. I don't know if you think, I just was curious if you could speak to that in the context of the public discourse on bioethics, and if there's any implications.
That's a great point. And the slide that I showed with respect to the sort of the blank slate and the previous slide regarding the absence of natural constraints is related to your point. That is, there is no the givens of biological identity are not normative in this framework, right? Your body is an instrument. Your body, there's no if I am biologically male but my will is female as I understand it, then it's an injustice in a way not to allow me to pursue a life and to pursue projects that accord with that. With my will. My body is an instrument. If it's an imperfect instrument, then I should be able to change it in some way. And if for example, especially in the context of assisted reproductive technologies, you're talking about I should, if for whatever reason I'm not able to conceive in the usual way, I should be able to harness the powers of science and biotechnology to alleviate that injustice. That's an injustice when nature imposes a constraint on my will. If I become pregnant, if I'm a woman and I become pregnant in an unintended context, it's an injustice not to allow me to have access to the technological interventions that will terminate that pregnancy so that I can be free to be an equal citizen. So I think and we didn't talk about enhancement, we didn't talk about other areas of the law where it deforms the doctor-patient relationship as well. The doctor is no longer a kind of professional whose job it is to seek the good of the patient as she sees fit, as informed by his or her training, right? The doctor is a kind of service provider. I come to the doctor, and this deforms conscience laws as well. If I go to a doctor and I want an abortion, if I go to a doctor and I want an amputation because I have body dysmorphism and I feel healthier if my limb is amputated, the doctor doesn't do it for me. There are forces that try to conform that those choices and the notion of autonomous decision making on the patient's part to the standard of care, right? Meaning the doctor, if they don't do that, then they are, or if they don't refer you to someone who will do that, then they're liable for malpractice. And you see this in Oregon in the context of assisted suicide, where if a doctor thinks that assisted suicide is not for the good of the patient, which is most doctors, thankfully, in this country, although in Europe it's not the case. The major medical societies here are mostly opposed to assisted suicide and euthanasia. That's changing in Europe, and it's worrisome that could come here as well. The doctors are compelled to do it because there are people who would make the case, there are lawyers who would make the case that if a particular procedure is legal and within the standard of care and the patient wants it, you better do it or refer them to someone who will do it, or you're liable for malpractice. And the given is not normative.
David Crawford.
Thank you for your presentation. It was very interesting, and I like your argument that what's at stake here is an underlying anthropology, or anthropologies, the clash of anthropologies, but that some of these issues in the culture, in law, and politics, and so on, are driven by a particular anthropology. So thank you. I wanted to just pick up on Dr. Schindler's opening question. And pursue it a little bit further, just with an example, because my concern is, I think that the anthropology that you're talking about is deeply embedded, in the type of rational discourse that's available to us, and therefore, what you end up with is a kind of tilted playing field, if you will. And an example of that, I think, is the contraceptive mandate. You end up with, of course, it has to be argued on both sides in terms of rights claims.
Right.
And I think my suspicion is that rights claims are a basic way of trying to talk about things without ever saying what anything is, but appealing only to clashing freedoms. So you never have to really say what something is.
Right.
And that puts, let's say, the church in an awkward position, because the reason that it's opposed to providing the benefits is because it has something to do with contraception itself.
Right.
But the church is in a position where her bishops, leaders of schools, and so on, are unable to formulate any sort of arguments that would be acceptable as within the pale of acceptable public reason, whether political or legal reasoning, that actually refers to things as they are, what things are. And therefore, but the other side is able to articulate, just as you said, look, I have a right to enter into the employment marketplace, and I have a right to my own autonomy and to enter into that marketplace on my own terms and so on an equal basis with everyone else. Well, that's very well understandable within the framework of liberal public reason, and therefore, which side is going to win ultimately? That would be the thing. So I just like your response to that.
No, so, there's a lot in your comment, and I agree with what you're saying. You see the rhetoric of opponents of the mandate as saying this isn't about contraception. Just to be clear, this isn't about contraception. This is about religious freedom, right? And I appreciate the tactical calculus that produces that kind of an argument. I mean, obviously, and frankly, it's a kind of genius on the part of the. And if you read, it's not a secret. I mean, if you read, there's a book called Double Down, Game Change 2012, written by the two crack reporters for the Washington Post. That is, crack isn't good. They don't report on crack. Who have extraordinary access to the campaigns of both candidates, Romney, and in the primaries as well. And it was 100% clear that the whole war on women narrative was devised to drive up a key constituency, single women, mostly single white women, to come out in force and vote for and they thought that what we'll do is we'll make this about contraception and we'll focus on contraception because contraception is another way to separate the leadership of the Catholic Church from the faithful, because this is an area in which there is deep disagreement, historical disagreement, some moral theologians still really mad about Humanae Vitae. And it was a kind of a genius selection of issues to push all those buttons, although they overreached, and interestingly, they initially overreached because they seem to want, you have some sympathetic plaintiffs, right? And people like E.J. Dionne and others were like, well, we're pushing this too far. But then the sort of accommodations, which to my mind are mostly shams, were satisfying to those people who initially complained about it. But anyhow, but it's all procedure. They're arguing procedure, right? You're right. The arguments about rights are to keep it at sort of a level of procedure. I'm entitled to make a certain kind of choice, free from coercion. I'm free to create an institution that has a particular kind of identity without you grafting stuff onto my plan, my health plan, government. I'm free to be an employee. And then the question becomes who's more sympathetic. And this relates back to my first point, is it's all about rhetoric and sympathy and sort of capturing the hearts and minds of the public. And I agree with you. And the thing is, once you start talking about rights, you're implicitly embracing this sort of individualism, right? You're sort of like, it's me, my rights against somebody else, my rights against the government, my rights against Hobby Lobby, or Notre Dame or Catholic University. And I think that that's it's a way of masking what we're really talking about. And the Obama administration is betting on the fact, and they bet right, that we don't want to talk about contraception, which is why Hobby Lobby was such a genius plaintiff, because as Protestants, they were just interested in the abortifacient, four potentially abortifacient interventions that they opposed. And that was an extraordinary choice on the part of the litigators to use that as the mechanism to go to the Supreme Court. It was a great idea. And in that case, who didn't want to talk about what we're talking about? It was the government, and to the extent they did talk about it, they simply they denied what the FDA says in their mechanism of action for those four things, that their mechanism of action might be the prevention of implantation of a newly conceived human being. But your question is, well, I mean, I don't know if it was a question. You seem to suggest that we should talk about what we want to talk about, rather than hide behind procedural rights of free choice to create a certain kind of institution, or to be a certain kind, or to participate equally in the marketplace as an employee. What would that look like? I mean, I can understand someone saying, I'm not going to get out there and make the case for contraception or against contraception. What I'm going to talk about is having institutional integrity. At the same time, though, this is a problem. I mean, if you go on and on not talking about something because you're worried people's reaction to it, then it's a self-fulfilling prophecy. How many homilies have you heard about contraception? Mm-hmm. Not many, right? And I don't mean to, I'm not blaming priests. I'm just saying that it'd be valuable to have formation on these questions that we're afraid of, and to make the case. I think the case against the Catholic case against contraception is quite beautiful and appealing, and there might even be a cultural moment where people are willing to kind of receive the idea that we should think about procreation the way the church thinks about it, not about and sort of the new life supervening on the conjugal act, rather than a rational plan that we sort of, sometimes with the help of technicians.
Let's take one more question so that we can enjoy a dessert reception with Professor Snead. Margaret.
Oh, just on the question of the hypocrisy when it comes to the autonomous individual, goal-setting individual we're trying to construct, and dealing with this apparent hypocrisy. I know Mary Eberstadt's written about this when it comes to this whole food movement now and all the things that we're outlawing and banning, and this was just brought up. But doesn't that reveal not just a hypocrisy, but not simply a hypocrisy, but that what we're really aiming at in the construction of this autonomous individual is unraveling the basic constitutive relations that we find ourselves in as embodied beings. So being born, being people who are already facing the opposite sex just by being of a certain sex, and then being mothers and fathers. So I want to segue a little bit into what you said at the very end about the invisible other. I mean, it strikes me that all these problems, abortion, ARTs, and so on, really, I mean, don't they have to do with actually those who are very close to us? So I mean, you had a picture of Terri Schiavo, and she was someone's wife, and it's a problem, and then there's the baby that I have that I don't want, or there's the baby that I can't have and that I want, the baby that I got but has Downs. I mean, it strikes me that those are the most problematic relations that challenge this doctrine that we have that's very ingrained in our mentality and in ourselves about being autonomous. What do you think about that?
Yeah, so let me just be clear that I understand what you're saying. So you're saying that these contexts of the cognitively disabled family member or spouse, the situation of the baby in utero, the situation of these are actually serious challenges to this notion of radical autonomy because of the natural intrinsic connectedness of those situations.
Yeah, more than the poor in India. I can. It seems to me you've got a lot of philanthropy today, and I'd always. Yeah, I mean, you've got the Bill Gates and the others who spend a tremendous amount of money on the poor, and in a certain sense, that's very easy to do.
Right. Yeah. So I mean, I do think it's in some ways it's more. I think it strengthens the point that what's really going on here is, and it's amazing that people still make the arguments. Well, two things. One is I think it confirms that radical individualism is at the heart of this, because even in these deeply intimate relational settings, people are making the case for autonomy. Judith Jarvis Thompson's insane violinist, or People Seeds, or whatever. I mean, that's an unrecognizable analogy. Why would you make that analogy? You must really be committed to the concept of radical autonomy to continue to trade in those images and those concepts when this is the area that you're talking about. The other piece of so that's in some and so that in some ways that's horrifying, right? It's horrifying that people are sticking to this conceptual attachment to radical individualism and autonomy, even when you have the most humanly intimate setting, right? That's kind of problematic. On the other hand, it's good news because what I'm trying to appeal to in some ways are the moral intuitions of people to say, you don't really think that you're not connected to your spouse who's in the bed, do you? You don't really think that you're not connected to this baby that's growing inside you, that this is an alien invader that you have the right to repel using lethal force. It's an aggressor that you deal with in a self-defense frame. That's not really true, is it? And I'm optimistic about ultimately being able, because this is what you look at a kid, right? I mean, my 9-year-old, you talk to him about these kinds of things to the extent that it's appropriate to talk to a 9-year-old about. I'm not showing him pictures like anyway, and they get it, and they get it. And the further away we get from the sexual revolution, and the further away we get from that generation of folks who are just marinated and can't even see beyond the concept of autonomy. And you see this and it's not as great as I would hope it would be, but you look at polls and you see polls that suggest that young people, it's easy to say why abortion is bad. Don't kill somebody. Don't kill a baby, right? It looks like a baby. I mean, an embryo doesn't look like a baby, but it actually does look like a baby because that's what you look like when you're at that stage of development. But it's easy to explain to someone who's not infected with that cultural formation from the sexual revolution forward, and as these people leave the stage and they're replaced by others. In fact, you see a lot of this conflict in the writings of people who are aging feminists, radical pro-abortion rights feminists, condemning their younger feminist colleagues for not being robust and energetic enough in defending abortion rights. They don't get it. Gloria Steinem is really upset about this. Faye Waddleton is really upset about this. So I'm optimistic. Now, it's interesting, though, because you see this, and this gets back to the question about the biological given. I'm not so optimistic about the notion of biological complementarity of man and woman. The same polls, don't kill a baby is easy to get. You put that on a bumper sticker. Abortion is mean. I've seen that on a bumper. That's pretty effective. How do you make the argument about the complementarity of man and woman and the good of the conjugal union? That's hard, right? What do you do? I mean, you've got some people who have taken a stab at it. My colleague Robbie George and Ryan Anderson Shreve produced a book on this. Robbie's got another book coming out with Pat Lee making the same kind of case. I don't know. Is that how you can persuade people? I'm not sure. I don't know. I see the same people coming to the pro-life position at the same time, embracing the view that that same-sex marriage is legitimate, and at the very least, we should just let people do what they want to do. And it's for the same reason. It's because of equality. It's because we want to treat people compassionately in a loving way, and we don't want to harm them. We don't want to kill a baby, and we don't want to prevent people who love each other from constructing a life together. Those two views are traveling together, right? And it's hard to explain to a layperson who doesn't who doesn't understand, the importance of, or not doesn't understand. That's not a nice way to say it. Who doesn't? I mean, you can't start with banning gay marriage in your argument. You can't say you got to ban gay marriage. What are you talking about? Isn't marriage just a contract between two people who love each other, and in the state they come together to pursue a life together? If that's what you think marriage is, it's really hard to see why gay marriage shouldn't be legal or promoted, right? But if that's what you think marriage is, then you've got first order issues with anthropological premises. And Robbie says this. Robbie says that it's not that gay marriage should be disfavored. He says it's not possible, in his argument. It's not possible for anyone other than a man and woman to be conjugally united in that way, right? But how do you put that on a bumper sticker? It's kind of.
But maybe one way to
run into some censorship issues.
Maybe one way to draw all of these different threads together would be to just say, in terms of the picture that you've articulated, the humanly appealing picture, to say that the body is meaningful.
Yeah, and
The
even,
body is
even Michael
meaning-
Sandel says this, right? So Michael Sandel from Harvard, who was on the President's Council on Bioethics, wrote a white paper for the President's Council on Bioethics about enhancement and enhancing our children and interventions to make better children. And then he turned it into a little book. It was an essay in the Atlantic, and then he turned it into a book. He talks about the normativity of the given, right? He talks about the kind of how, but this issue, and Alistair McIntyre, you know, talking about the loss of teleology, the loss of the idea that there are ends in nature, especially ethical, you know, with ethical significance, is a huge earthquake in our culture and in our civilization.
Right.
And how do you recover that?
Well, that's material for another lecture. So thank Professor Snead.